Hello, it's Caitlin Jenkins, the family law vlogger here. This is the latest in the Stages of Divorce series, and today's vlog looks at what a form called an ES2 is and how it's used. So an ES2 is a form that's generally used in court proceedings called financial remedy proceedings, which are the court proceedings that are used if people need help sorting out their finances on divorce. The form is sometimes also used outside court proceedings, so for example in mediation or solicitor negotiation or a collaborative law process, because it's a very helpful, useful summary of each party's position as to what their finances are and what the other person's finances are. So basically, it's a schedule of assets and schedule of income. Down the left-hand side, it has various categories of assets. So it has property, it has bank accounts, it has a section for other investments, it has a section for chattels, so valuable items in the house, for example, and it has a section for other assets such as businesses, and also a pension section. And then at the bottom, it also has a section for each party's income. So far, so good. Then I think the columns in the form are a bit confusing because there are three columns. There's a husband section, there's a wife section, and there's a joint section. Now, in the husband, first of all, thing to say is that this form standard form use the phrase husband as a heading and wife as a heading. It doesn't use applicant and respondent anymore. It tends to use husband and wife. Sometimes it uses applicant and respondent, but often it says husband and wife. Now, obviously, in a same-sex relationship, that would need to be changed to husband and husband, or wife and wife, or to appropriate terminology. But usually the starting point is that either the generic phrase is either husband and wife or applicant and respondent. And then in each column, so let's take the example of, say, the husband column, it will ask for both what the husband thinks his assets are and what the wife thinks the husband's assets are. So you can put sort of both sides of the story. So you end up with 6 columns within this form so that each party can put their own case as to what they think the other party's assets are, what they think their own assets are, and also what they think the joint assets are. There's also a final column, which is for agreed comments. So any comments about an asset, which can sometimes be things like it was inherited, or it was acquired after the marriage had broken down, or those sorts of things. So it is a document that is necessary and required before court hearings, such as first appointments, and before negotiation hearings, which are called FDRs, or before a final hearing. The final hearing is when a court will actually impose an outcome if an agreement hasn't already been reached. And often you start off with one version before a first appointment, and then it gets updated along the way before each hearing. It's a really important document. It's the document that the judge looks at the most, I would say, in any of those 3 hearings, because it's a really useful summary as to what the assets are, but also where the gaps are. So, for example, before a first court directions a hearing, if the FDA shows that one person thinks the house is worth one figure, and the column shows that the other person thinks the house is worth a different figure, then it gives the judge the idea and the information to realise that either the parties need to sort of negotiate and try and agree the value of that house, or perhaps there needs to be a third-party independent valuation of it. So that's an ES2, very useful form, used in a court context, but sometimes also used because it is so useful in a mediation or context as well. So if you need any advice about your specific circumstances, then please do contact me or one of my expert colleagues in the Mills Reeve Family and Children team, and our details are below this vlog. Thank you.